Welcome to The Explainer. Today, we're diving into a genuinely thrilling legal showdown that made it all the way to the Constitutional Court of South Africa. It's a classic David versus Goliath story, but hey, instead of slingshots and stones, the weapons of choice here are intellectual property law, t-shirts, and the fundamental right to freedom of expression. On one side, we've got a massive, multinational corporation absolutely desperate to protect its pristine brand. And on the other, a tiny graduate project determined to mock that very corporate sanctity. It's a clash that really forces us to ask a deep question. Who actually owns the cultural space we live in?
So let's jump right into this by asking the very provocative question that Judge Sachs posed at the Constitutional Court. Does the law actually have a sense of humor? Because, when the irresistible force of free expression, usually in the form of a parody, meets the immovable object of property rights and trademark protection, sparks are absolutely going to fly. And as we're about to see, court decisions on this can be just as unpredictable as the judicial sense of humor itself.
The inciting incident of our whole story really boils down to this clash of imagery. You have the highly recognizable, iconic label for Carling Black Label beer, and then right next to it, a parody t-shirt produced by a small outfit called Laugh It Off Promotions. Laugh It Off essentially pilfered the massive brand's imagery, the color scheme, the typography, the whole shebang, to create a highly controversial statement. They definitely weren't trying to sell beer. They did it to make a very pointed social point.
Section 1. A provocative t-shirt.
Now let's look at the ideological jujitsu the creator pulled off here. It's really fascinating. He relied on a stark contrast in messaging. He swapped out the words black label for black labor. Carling beer became white guilt. And where the original cheerfully proclaimed America's lusty lively beer, the t-shirt bitingly read Africa's lusty lively exploitation since 1652, and added no regard given worldwide. The t-shirt took the brand's immense weight and popularity and turned it totally upside down to force a conversation about corporate practices and racial history.
Section 2. The brand versus the rebel.
1.4 billion. That is the absolutely staggering volume of 340-milliliter black label bottles that South African breweries sold in just the 2000 to 2001 financial year alone. To put that into perspective, that translates to roughly 350 bottles for every single man, woman, and child in the country at that time. This brand was ubiquitous. We're talking awesome marketing machinery, massive sports sponsorships, billboards on literally every corner.
So, contrast that Goliath-level corporate dominance with our David. Justin Nurse ran Laugh It Off Promotions as basically a tiny graduate project operation. He was a self-proclaimed brand atheist. He produced only a few hundred of these t-shirts. His goal wasn't to build a rival beverage empire, right? His goal was just to poke fun at corporate giants, to mock brand sanctity, and to challenge what he saw as mass-market mediocrity.
Section 3. Trademark law meets free speech.
Well, when South African breweries inevitably discovered these t-shirts, they were entirely unamused. They built their case on trademark tarnishment, leaning on Section 34(1)(c) of the Trademarks Act. Now, they weren't arguing that people were buying a cotton t-shirt thinking it was a cold beer. Instead, they argued that the t-shirt's message unfairly degraded their pristine selling power. They claimed that creating this unsavory, racially charged association tarnished their reputation and diluted the immense value they had spent decades building up.
The creator of the shirts, on the other hand, countered by wrapping himself in the highest law of the land, the Constitution. He asserted that his parody was fully protected free speech under Section 16. His argument was that powerful corporations use brand building to occupy our cultural space, our social space, and honestly even our headspace. Therefore, he argued, citizens absolutely must have the constitutional right to use those very same cultural icons to critique the corporations, preventing them from completely monopolizing free thought.
Section 4. The lower courts strike back.
Initially, things looked incredibly bleak for the t-shirt campaign. Both the High Court and the Supreme Court of Appeal sided firmly with the massive brewery. The Supreme Court of Appeal looked at the t-shirt and interpreted it as an unjustified, degrading racial slur against the company. They ruled that because Laugh It Off was selling the shirts for a profit, they harbored a predatory intent and were unfairly harming the brand's reputation. The t-shirts were interdicted, Laugh It Off was facing looming insolvency, and, well, it really seemed like Goliath had won.
Section 5. The Constitutional Twist.
But then, in a dramatic climax, the Constitutional Court of South Africa agreed to hear the case. And right here, they completely flipped the script on how we understand the balance of power between property and speech. Writing for a unanimous court,
Judge Molseneke impartially reminded everyone that in a vibrant, open democracy, free expression must be heavily protected. The court emphasized that it doesn't matter if a joke is in bad taste, or if a political statement makes people uncomfortable, or even if the expression is sold on a commodity like a t-shirt. Unless it crosses the line into outright hate speech inciting violence, it enjoys constitutional shielding.
So, the crucial takeaway here is this brilliant piece of legal reasoning. You cannot restrict constitutional free speech just because a corporation's feelings are hurt. To actually prove trademark tarnishment in this context, the company must show a probability of substantial economic harm. They have to prove that the parody is actually damaging their commercial sales or their market dominance in a material way.
And this, my friends, is exactly where the Breweries case completely collapsed. South African breweries had approached a court claiming the economic harm was just self-evident, but the Constitutional Court said no way. SAB failed to provide any actual evidence of compromised beer sales, any loss of market dominance, or any true commercial detriment caused by a few hundred t-shirts worn by university students. Because there was zero proof of actual economic harm, their entire trademark infringement claim failed.
Section 6. The power of parody. This landmark ruling was a massive victory for free speech. Judge Sachs wrote a beautiful concurring judgment highlighting the unique nature of parody. He noted that good parody is both original and parasitic. You see, in a society driven by consumerism, brands are the language of power. And sometimes hijacking that very brand is literally the only effective way to challenge that power. As he so perfectly put it, if the parody doesn't prickle, if it doesn't cause a little discomfort, it simply doesn't work.
Which brings us to the end of our explainer. This case proves that while intellectual property is incredibly important, for sure, it cannot be used as a shield to just silence the public. The courts ensure that the Goliaths of the world cannot dictate the terms of our cultural conversations. So the question I want to leave you with today is this. In a world totally dominated by ubiquitous megabrands, how will you use your voice? Thank you so much for joining us for this explainer, and keep asking the big questions.